there any objections to these exhibits?
Your Honor, Mr. Vasta went to the restroom.
Your Honor, I think I'm only going to seek admission of, I believe it's 397.
Can you see it?
Oh, actually, I take it back. It is 396. May I approach, Judge? You'll need the scissors. And I can advise the court, I've not looked inside the exhibit, so I think I know what it contains, but I'm not.
Oh, here, look.
Thank you, Judge.
Okay, folks. What do you intend to get into, Mr. Clemency, and so I can hear whether there's some objection and deal with it?
I was just going to ask to admit the exhibit, Judge. I wasn't going to really elaborate upon it. It goes to the fact that Mr. Flores does in fact like to control women.
Well, he's already answered the question.
And Your Honor, so you can take a look at that. That's a document that was authored 18 years ago.
Well, he's answered the question under State versus Woods. First of all, he's answered yes, it's collateral. It only becomes an issue is if your client's got compatible documents, and he denied that in fact he did that. So what about the other exhibit that you opened up before and we took the break?
No, that's this, Judge.
Okay, well, so you're not going to go into either one of these two exhibits? Well, you're not going to get into that one.
Based upon what I understand to be the court's position, no.
Are you going to do 397, the Corolla one, or the other one that you had to 390?
No.
Okay.
Your Honor, just to let you know, we're trying to track down Mr. Margolis. Obviously,
He's in the back.
Oh, okay. Obviously, before Mr. Cook testifies.
Well, he's in back and he's
Okay.
said he's available and he's out of trial, and if he's not, and I was going to find out whether we're going to finish Mr. Flores today, so before I released him.
I'm very nearly done, Your Honor, just with very few additional questions.
Okay, well, then make sure Mr. Margolis doesn't go very far.
Your Honor, may I ask the court to open up 397 just so that I can know what it is for sure?
Your Honor, I think since the cross is almost over, we may need to, it might be a good idea to readdress exhibits 349.001 and 349.002 as prior consistent statements.
Can I have the scissors, please? More cards and notes. So it's continuation of the same thing. He's already admitted that he had that relationship.
That's fine, Joe.
Absent state not going into it on redirect, offering some kind of explanation.
That's fine, Judge. I'll leave that alone. No problem.
Okay, before I bring the jury back in, Sydney, did you get me the minute entry of February 11th of 2011? Is that the date of that minute entry?
I think it's 2013, Judge.
2013. Okay. Council, when we come back on Wednesday to talk about this thing, I've looked at that minute entry, but I've also looked at the minute entry dated 12/6/2011. Judge Brnovich ordered, court finds that Rihanna is a victim in this case under 134401 subsection 19. No further contact shall be made by the defense absent a court order. Second page, it says the court finds there has not been a showing that pretrial interviews with victims are necessary for purposes of mitigation. So when you come back Wednesday, please be prepared to address why you're not in willful contempt for violating a court's order. Court was very specific, no contact absent court order. Court made a finding in terms of mitigation. I've read everything, so you'll have a couple days to prepare, but regardless of what the victim's Bill of Rights says, regardless of the arguments, there is a very specific order by a judge, no contact with this person absent court order. So, just so we're all knowing where we're coming from when we discuss it on Wednesday. Okay, bring the jury in.
Your Honor, when would you like to address the 349.001 and 002 documents? I think the defense is ready to end their cross. Do you want to take another break at that point in time?
Yeah, let's finish up. Members of the jury, it's come to my attention that the conflicts on the 11th or the 12th and the 13th of March no longer exist. Now, I didn't bring anybody in last week after those days fell out, and right after the 12th and the 13th, we have the spring break that's going for 8 days. So I haven't made a decision, but I thought I would alert you, and I already see some smiling faces, so I'm sure that we're going to get some pushback. But quite frankly, folks, I really would like to use those 2 days, to at least one of those days, to get testimony in that week. And so I'm trying to be as accommodating as I am, but I also have a question of trying to get this matter brought to some conclusion. So tomorrow morning before we get started, write your notes to Sydney so I can review them and discuss them with the lawyers and make a decision by noon. Okay? Mr. Flores is back on the stand. Counsel, you can resume your examination.
Thank you, Ron. And just before we broke, we were speaking about the fact that you like to have these master-slave relationships with women.
I asked what you meant by that. And I said,
Well, question had been, had he been in a master-slave relationship with a specific woman? So the answer to the question is yes or no. Were you in a relationship with a woman?
yes,
Okay.
And in the context of that relationship, you were the master.
correct,
The woman was the slave.
correct.
Now, you also video recorded sex with women,
Yes,
including my client.
yes,
And that was done with a hidden camera?
with a nanny cam,
I'm sorry, I didn't hear that.
with a nanny cam, yes, a hidden camera type,
So it was a hidden camera.
yes,
And she didn't know at the time that you were recording.
at the time she didn't.
Nothing further, Judge.
Redirect.
I guess we'll start with the slave master thing that the defense was just talking about. Is that a typical kind of relationship you have?
No,
Did you have a relationship like that with the defendant?
absolutely not.
How long ago was it since you had that kind of a relationship with the woman?
Which is 1996, so 18 years ago.
Now, in cross-examination, you had mentioned that you had actually, I guess, first met the defendant after contacting her on seekingarrangements.com, is that correct?
Correct.
What kind of a website is that?
It's a matchmaking website primarily designed for people who want a relationship that doesn't have a lot of strings attached, where it's actually a very explicit arrangement for people who aren't looking for marriage or a long-term commitment.
So at that time, that's what you were looking for?
Correct. I was not looking for marriage or a long-term commitment at that point.
Is that a website that encourages or facilitates financial arrangements?
It allows people to make arrangements between the two parties if there's finances as part of it, yes.
I guess I'm not sure how that website works. Is that like in a profile that you know up front what somebody is looking for when you want to meet them?
It's been a long time. Typically, the women who go on it say that they're needing financial assistance of some sort, and typically the men, as part of the arrangement, would offer some contribution towards their expenses.
And so that's something that typically you would know up front before ever asking to meet someone.
Or you would discuss it at the first meeting.
If you can remember, when you saw the defendant's, was it a profile? When you saw her profile on the seeking arrangements, was there some sort of financial requirement from her end?
There was not one explicitly stated, but the implication was that she was looking for financial assistance.
So that was implied in her profile?
Correct.
Now, on cross-examination, you had talked about, you first saw her at the pizza place and then you ran into her profile on this website.
Correct.
Was there a photograph associated with the profile on the website?
Yes, that was how I recognized her.
Okay.
I had seen her at the pizza place about a week before, and I was in the process actually of canceling my subscription to the website, and I happened to look through and recognized her from her picture.
So it wasn't just by chance that you saw a profile and met and it turned out to be the same girl?
No.
When you saw her at the pizza place, what did you think?
She was incredibly attractive. She was wearing a very nice oriental outfit, very exceptionally attractive woman.
So when you saw her profile on the same website that you had been, or had used, or had a subscription to, what were you thinking?
I was thinking that it was a fortuitous chance.
How long was it after you first, I guess, saw her profile that you made contact with her?
I sent her an email that day, and we communicated by email for perhaps 2 or 3 weeks before we actually met.
So for the first couple of weeks, it was just email exchanges.
Correct.
During those email exchanges, were you, I guess, hashing out financial arrangements?
No, we were just getting to know each other. About a week in, I did tell her that I had seen her at the pizza place, and she said yes. I asked her people she was with, and she said that it was her ex-husband and her kids. I inquired why she was dressed so nicely to go to a neighborhood pizza place, and she joked that she liked to remind her ex of how good she looked and what he was missing.
Okay. Like she just rubbing it in his face? Now, the defense attorney was talking about your February 20th, 2009 interview. That's not something that you brought up during that interview? Or was it?
No, in general, when friends inquired how we met, we told them that we had seen each other at the pizza place, and then we subsequently bumped into each other at Dashes. We did not offer that we met on the website.
Why not?
Embarrassment.
Now, in that February 20th of 2009 interview with the Gilbert Police Department, did you go down there seeking to offer them any information?
No, they asked me to come down there while they were waiting for the search warrant on my house.
And did you come down?
I did.
How did the interview go? Was it just you volunteering information, or were you answering specific questions?
I was answering very specific questions.
You had mentioned a few things that I'll say you weren't completely honest about. One of the things was about how you had met. You said you first met at a pizza place. That wasn't accurate.
I first saw her at the pizza place, and then we actually met at my house after communicating.
The defense had indicated you hadn't mentioned anything about her debt, the promissory notes, the discussion about trusts or an insurance in that February 20th of 2009 meeting. Were you asked about that kind of stuff?
No,
At that point in time, the search warrant hadn't been served on your house?
correct, we were still waiting for that.
Now, right after that interview, you went to your house and the search warrant was served. Do I remember that right?
Correct.
At that first search, what things were taken?
They took my main computer, they took Reese's laptop, they took the thumb drive, and I believe that was it.
This was all related to the stand document,
Correct.
and that's the day you went down to the Tempe Police Department, and then later the Gilbert Police Department with Stan.
Yes, correct.
Now, the subsequent interviews that the defense wanted, or that the Gilbert Police Department wanted to talk to you about, the one in March and the one in November, had to deal with, I guess, documents that were found on your computer after the search warrants had been served. Is that right?
Correct.
When they asked you, did they ask you specific questions about those documents?
Yes.
And did you answer the questions that were posed to you?
Yes.
Now, you had indicated on cross-examination with the defense attorney asking you about, I guess, I'll call it your business prowess. Are you, in your opinion, a good businessman?
When my heart's not involved, probably.
With your consulting business, do you consider yourself to be very professional and analytical about how you conduct your business? Do you tend to do a lot of research in your business?
No, most of my work is statistical analysis.
I'm not good at statistics, so if you could, does the statistical analysis involve people providing you with information and you doing a statistical analysis of the information?
Today's nomenclature we call it big data. I look at massive transaction databases to try to analyze customer demand patterns, figure out how much inventory and which types of product lines companies should have.
Who provides you that
The
data?
clients provide the data.
Do you check to make sure that clients aren't lying to you?
I verify data integrity, but I assume the data they're providing is correct.
And based upon that data, you do your statistical analysis and provide them projections?
Correct.
Now, you said that you're not a sucker when it comes to business. Would you consider yourself a sucker in other areas?
I do not have good luck in love.
Do you consider yourself having been suckered by the defendant?
Yes.
You were suckered out of your money. Now, the defense attorney had asked you about the interest you were charging on the promissory notes. We'd gone through the spreadsheets, and I don't want to go through all of them. Again, they're in evidence. But at first, you weren't charging any interest at all. Is that right?
Correct.
Now, the first promissory note starts, I guess there was a discussion about it being paid pretty quickly by an IRA. Is that right?
Correct.
At the time that you were providing these loans, did you expect a fairly quick payout of the money?
Initially, yes.
And when you say initially, what time frame are we talking about?
The first few months.
After that, did your expectations change?
Yes, as I said before, about the second month, we had this discussion about the insurance policy on our Biscuit's father, which she then told me she was pursuing with the phone company, and that was going to be coming through. And she also then shortly thereafter told me about the trust that was tied up. So,
Based upon the knowledge you have, both as your training with the insurance that we'd already talked about, and anything that you were told by the defendant, did you expect that that insurance policy, at the very least, was going to pay out pretty quick?
I figured probably within a year or so, yes.
Now, I guess in that time where you're not charging interest, how would you characterize your relationship with the defendant during those, I guess, that first month or so?
The first few months, we just clicked wonderfully from the very beginning, and so we were getting closer and closer as time went on.
So at first, it was, I'm going to use some slang terms, it was just hooking up.
Because we communicated by email beforehand and shared a lot of things, both being single parents, it felt to me more than hooking up.
So even from that very first meeting, you didn't look at it as just meeting somebody for sex?
No.
Now from that, I guess in that first meeting, did you offer at all to give her money?
Yes, because of the context in which we had met, I asked her if she wanted to discuss an arrangement.
And what was her response?
She said no, she didn't want that to be the basis of our relationship, that her friend Sabrina had kind of put her up to putting the profile on the website, and she felt a connection with me as well, and didn't want an arrangement to just see where our relationship went.
Again, since I don't know the dynamics of your relationship or how you were feeling, if she had just asked and said, you know, hey, look, I need help paying my bills, I'll see you as much as you want if you're paying my bills, would you have done that?
Yes.
So that wouldn't have been an issue for you? Would it be fair to say that when you first saw her profile on the website, given what you had read, you kind of expected that kind of relationship?
Yes, I did. I expected her to ask for a kind of regular monthly contribution.
During the course of your, I guess, we'll call it the relationship, did she ever ask you to transform the relationship you had into one where you were just giving her money for bills and those kind of things to have the relationship? At no point?
No.
Now, going back to when you started doing promissory notes with the interest and those kind of things, at that point, before the promissory notes were signed, she just turned to you and said, look, I just want, you know, this money to be part of our relationship status, not as any sort of a lien or guarantee on my life. Would you have done it?
Probably.
Now, the defense attorney had asked you, I guess in the days that followed her first arrest, about the expenditure of money that you were laying out. And I guess in the context, he asked why would you bound out somebody that you were fearful of? You responded you were no longer concerned about her harming you. Why was that?
And at times when I was concerned about that, I wasn't sure if that was just my imagination or what was going on with her. And after a horrible thing that happened with her ex, she was calling me from jail, hysterical, ready me to bail her out, and I was not fearful of her at that point.
Again, based upon your direct testimony in the context of the cross, would it be fair to say that your concern stemmed on whether or not she was planning on killing you versus Dave?
At that was one of my concerns, yes.
Once Dale was assaulted, that concern seemed to evaporate?
I didn't know if I was just imagining, I didn't believe she was capable of that, or something like that.
Is that because you loved her?
Absolutely.
During the course of the 2 years that you were with her, tell us what you were feeling towards her.
I was in a wonderful, loving relationship with someone who I deeply cared about.
Is that why you overlooked a lot of these, I'll call them discrepancies for lack of a better term, with regard to her finances?
Yes, I trusted her.
At the time that you were hiring the attorneys and bonding her out and that kind of stuff, was she telling you about who had assaulted Dale?
Initially, she said that she had blacked out and didn't remember, but then subsequently, she showed me the document that you introduced into evidence previously.
And that's the, I finally remember.
Correct.
Now from, we'll say January 14th until, I guess, when after that, were you still seeing her pretty much every day?
Until the assault.
Is that the day Dale died?
Yes.
So right around February 9th.
Correct.
Mr. Flores, I want to hand you what's been admitted as exhibit number 432. You had looked at that document before, is that correct?
Correct.
Now that's the document in which you, through your attorney, raised some concerns about the possibility of you being involved in crimes. Is that correct?
Correct.
Now, the defense attorney listed, I guess, several of your concerns. One of them was accomplice to commit murder. What was your concern there?
Because I had a close relationship with her, there was circumstantial evidence that could be misconstrued in a whole variety of ways.
Would one of those things that you considered was the fact that some of these documents were found on your computer?
Correct.
Some of the printed out documents were found in your home.
Correct.
That you had helped, I guess, edit some of these documents.
Correct.
Were you in any way, shape, or form at the house when Dale was attacked?
I believe I set foot in that house twice over the course of a year, and I was not there that evening.
So one of those times, wasn't it, 2:45 in the morning on January 14th?
No.
Okay. At any point during the course of your relationship with the defendant, did you ask her or talk to her or assist her in killing her husband?
Absolutely not.
So you were worried what somebody might look at these documents about and piece together.
Correct.
Do you have any actual concern for yourself that you were an accomplice to a murder?
No.
One of the other things that the defense attorney was asking about was hindering prosecution. What was your concern there?
It was the editing was Dan's record.
I assume it would be for the same reasons you were concerned about those documents.
Correct.
Now, the last one on the list was, I guess, these images that were found on your computer.
Correct.
At the time that the police were taking your computer, were you aware that those images were on your computer?
No.
Objection, Your Honor, beyond the scope of cross.
Sustained.
Motion to strike.
Granted. Jury will disregard the last comment.
With regard to, I guess, those charges, what were you concerned about?
That I would be charged with something that I had no knowledge of.
And that's why you asked through your attorney for immunity.
Correct.
And you'd already, I want to show them to you just so you know what I'm looking at. Exhibits 430 and 431 that are in evidence. This is the immunity petition and the immunity order from the court, correct?
Correct.
Now in exhibit number 430, it's also got the letter attached from the United States Attorney District of Arizona. Is that correct?
Correct.
And Mr. Flores, what I want to do is talk to you regarding your understanding of the scope of this immunity, all right?
Counsel, if you go into that area, it's beyond the scope of cross, and so I'm going to preclude you from doing it based upon prior rulings that I've made. So. Sydney, take the jury for a minute.
Please rise for the jury.
Be seated. Cross-examination, I stopped the defense lawyer because they went into attorney-client privilege, and now you're opening the door to attorney-client privilege, which means I got to grant recross, and on the same thing in terms of what's on the computer. Do you really want me to get into, let them go through every one of those images on the computer to show the jury what images they are to figure out whether or not he had knowledge or not?
Your Honor, that's not where I was going to go with my question.
Well, that's exactly where you're going with it, because his understanding of the agreement's going to come into exactly what his lawyer told him.
Your Honor, actually, what I was going to try to flesh out was use versus transactional, and that would be it.
Well, fine, and he's not an expert, and you can argue it to the jury, and I'm not going to allow him to testify to the jury as to use versus the other kinds of immunity, one way or the other. But, you know, I don't know how many times I have to tell people about what they need to do or not do, and they choose to go back into these areas over and over again. The fact that he had a computer, the fact that there were images on it, you've made all your representations on the record that the county attorney's office wouldn't have charged him, which is, you can take that position as if you want, but the reality is state prosecutes people every day for the images, and I tried to limit the scope, that he had items on it, there were potential for him to be prosecuted on it, and I tried to keep it down to 5 questions. I gave you the 5 questions. I chewed all over the defense lawyer because he didn't follow my script, and then he backed away to finally ask the final question. And on redirect, you choose to plow through this ground again. If you really want me to get into it, I'm going to give him recross, and we're going to let the jury see every one of these images and test whether or not he's lying about whether or not he had knowledge of what's on that computer. Is that really where you want to go with this?
No, Your Honor, not at all. I just wanted to make sure that...
Sure, you just want him to say he had no knowledge what was on that computer and prevent them from being able to attack that. And I've tried to keep that out of there, and I'm going to keep it out of there. And if you don't like my rulings, you could have taken a special action. And today is a classic case of everybody deciding they're going to create their own rules. Well, it's ending now. We're not going into that. We don't need his help in defining the agreement. The agreement speaks for itself. Everything else is argument. Now, you asked whether or not those other exhibits are going to go into evidence. The rule on consistent statement says they're allowed to come in if there's an allegation of recent fabrication. Where in the cross-examination did he accuse Mr. Flores of recently fabricating the testimony that he gave? Not fabricating it, recently fabricating it.
Your Honor, during his cross-examination, he talked about the interview on February 20th of 2009. Among other things, said you didn't mention about the debt, the promissory notes, the trust, the insurance. You didn't mention a plot to kill Dale. All of these things going in, talking about what he didn't mention on February 20th of 2009. Then they start talking. Then there was the discussion about the immunity agreement, and I don't have the case. With the admission of the immunity agreement, and the documents are in evidence to show when the immunity agreement was actually entered. Under State versus Jones, the Arizona Supreme Court dealt with a similar issue about prior consistent statements when the defense attorney cross-examined the witnesses regarding an immunity agreement. That court had indicated that because the defense brought in the immunity agreement, that the prior consistent statements of those witnesses that were made prior to the immunity agreement would be admissible to show that he did not fabricate his testimony on the stand after the immunity agreement, and they would be admissible as a prior consistent statement.
What's the citation?
It is 197 Arizona 290.
Sydney, go get me the volume, please.
And if I have a copy of the...
No, I'll get my own copy. 197 Arizona.
Your Honor, I believe that discussion starts on page 299 to help the court get to the...
Well,
it's fairly lengthy.
In terms of the examination of what he told the police officers has nothing to do with whether or not his testimony in courtroom here is a recent fabrication. That's what the rule provides.
It does, Your Honor.
And so asking him what he told the police and didn't tell the police doesn't, that just shows he made inconsistent statements at other times. And it's nothing to do with what page you're referring to in the case.
Your Honor, it's page 299. As it starts at the end of 298, Your Honor, and spills over into 299. 299 is the bulk of the discussion.
And you're saying that because he did the immunity agreement that and this statement was done beforehand, that his motive to fabricate afterwards determines this?
Your Honor, I'm sorry?
I'm not even sure. I read the case. In this case, he has certain items on his computer that the police sees. They're on his computer. He testified that they were made at or about the time the events were taking place, and the defense really never cross-examined him on those issues. Matter of fact, they really didn't cross-examine him on the spreadsheets. They assumed the spreadsheets were correct and went through how much money. Where they went into it is to show that when he first talked to the police officers, he didn't include essential facts. The immunity agreement came not as a result of anything that happened in this case. It's because of what was found on the computer. And because of that, because when in December the state said, well, we have no intention of prosecuting him, so there is no issue. And then all of a sudden, after people thought about it for a while, whether or not he's really going to admit that this is his computer, they decided that he may be incriminating himself and he needs an immunity agreement. The state went out and got him an immunity agreement. So I still don't see where there's a charge of recent fabrication through cross-examination. If anything, the defense conceded that all of the information he gave about the relationship, how much money was done in the relationship, the timing of it, was accurate. So I find that it's still in violation of the rule and it's still hearsay.
Your Honor, I will of course abide by your ruling. I disagree with it, but I will abide. The other thing that the defense went into on cross-examination was whether Mr. Flores called the police or did anything in response to being told about these plots and those kind of things. What he did do was create those documents so that if something happened to him, these documents would be found to give a backdrop. The defense is attacking Mr. Flores about the unreasonableness of his actions with regard to contacting the police and those kind of things, and at the same time not allowing Mr. Flores to explain what steps he did take to try to protect himself in case something did happen to him with regard to his fear.
It's not my recollection of because if the fact is he didn't do those statements until after he felt threatened, then they're not contemporaneous notes. But from I'd heard of his testimony, and what I struck before that is he was taking notes of what was occurring, and then he went back and re-edited the notes. And so I disagree with your premise that somehow this is going to be a record, so if anything happened to him, someone would find his computer, would find that what was happening one way or the other.
Your Honor, I believe the notes themselves state that. And we can take a look at Exhibits 349.001 and 002, but that's what those documents, the printed ones that we found, that's what they indicate is for the purpose of him writing this stuff down.
Of course, we're relying on the printed. Was there anything found on the computer of these?
Yes, Your Honor. And originally we had talked about these documents to lay the foundation for the computer forensic analyst to timestamp when that information appeared in the computer. Not to introduce the documents per se for the truth of the matter asserted, but to establish, because of this implied charge of him fabricating testimony for immunity and those kind of things, to timestamp the exact time that those first start showing up on computers in Mr. Flores' house, so as to, I guess for lack of a better term, conclusively establish that this information, these statements, are being recorded prior to any possible motive for him to have lied about it.
Well, now you've now twisted the facts again. You're now saying that there was an inferred allegation that he changed his testimony in order to get the immunity agreement, and that's never been the case. It's never been an allegation. I heard none of that in cross-examination, one way or the other. What I heard was he entered into an immunity agreement because he thought he was going to be prosecuted. And he was going to be prosecuted for possible accomplice to first-degree murder, obstruction of justice, and possible prosecution for child pornography. Those were the three reasons he entered into the immunity agreement. So, and his testimony, for the most part, has been consistent from day one. They never really attacked his, other than the fact they've attacked his credibility as a witness by showing motive and other things, but I don't find it, and I'm not going to allow him in there. So, admission of evidence is at the discretion of the court, and the court finds that under the circumstances, the foundation hasn't been met. So,
Your Honor, I'd be heard on one topic quickly.
hurry.
Just, well, he did also, again, mention the attack on Ms. Devault after being told not to do that, but I would also respectfully ask the court to instruct the jury to disregard his statements about not knowing how the images got on his computer. That is beyond the scope of cross. I was going to object. You beat me to it.
Well, I stopped it, and I'll make sure that the jury disregards any.
Thank you, Judge.
Okay. Now we're going to have juror questions, so let's get going.
Please rise for the jury.
Please be seated. Earlier, I did not allow the state to get into an area about the images found on the computer. It's not what this trial is all about.